Hello, hello, hello. We've got some fun stuff for you. First of all, I have to tell you the thumbnail. Well, that's Jessica Hutchinson's fault. We have to assign the blame here. Let's assign blame first. Then I see Zach's in there. He's at fault for the Swinger Karen clip in front of Simpson. And of course, you almost can't get through the stream without part of it being Alyssa's fault. She's got a wacky granny for us. So let's get this thing started, shall we? For those of you who are not aware, where are we here? For those of you who are not aware, the attorney that appears here was previously in front of Judge DeSanto.
The first thing.
Now she's bringing her crazy to Judge Simpson. It's just as bad as it was before. None of it makes sense. Let's carry on, shall we?
You guys are going to have to switch sides. State your appearances, please.
Good morning, Your Honor. This is Megan Dalbala on behalf of the plaintiff, P84205. May I please state your name?
My name is Maria Payne.
Peterson. All right. It's a date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
First of all, look at Judge Simpson's face. Like, what? Why are we doing this? Second of all, I still don't have her name. All I know of, the only way I can refer to it as Swinger Karen's attorney. She's a hoot. In the last appearance, she was dressed like a disco ball. In this one, she's gone full PTA mother. In both, she makes no sense.
A procedural issue?
Yes, I can stay on the record.
That's right.
Oh.
What? No, well, then I've got to have them up here. I guess, what is it?
Okay, so there is a counterclaim, which is what this is separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that at the court's time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This has gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today.
Okay.
I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I don't like people. I do not like people accusing others of things like that without substantial proof.
Judge, I don't think you understand who you're dealing with. My client accused the judge of being involved in a swingers club in my last case. And I don't plan on stopping.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's
By whom?
by former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but
He's
I understand
been held up. He was in court here Monday, so I don't know why he's not that difficult to get a hold of.
Okay.
Coming in on the date.
He's hard to get a hold of. Judge is like, yeah, I saw him on Monday. I don't know. It might be a you thing. Probably doesn't want to talk to you.
Trial, asking for an adjournment of these proceedings is not going to happen.
Okay.
So you guys either can try to resolve this thing, or we're going to try it.
Okay. Fair enough. Then I would request a brief recess to please speak to the defendants.
Okay. See if you guys can work it out. Court's going to stand in recess.
By the way, that's not strange. As a general rule, it is frowned upon to ask for continuance the day of trial unless there's a damn good reason or you've put feelers out a few days ahead of time. Because people bring witnesses and do things and get ready, and the court is just generally wanting it disposed. So there is a strong presumption against such things.
14A District Court back in session. The Honorable Jake Senator Simpson.
You may be seated. Back on the record, court does call the case Finney versus Sedona. All the parties are present. And how did the conversation go?
It wasn't entirely productive, Your Honor. So we have back from 2021 a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's civil bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as the defendants are now pro per in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the condition of the property as against my.
What the hell are you saying, woman? You've entered an appearance as an attorney and said the claims are not cognizable because they're pro per. I don't even know what stupid shit you're onto. I can't even follow it, and I'm an attorney. I know it's wrong. Judge Simpson knows it's wrong. But we're just like, what were you pretending to say?
My client for relief. As
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint.
Which is number one, wrong.
where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defenses, given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court. So
I don't, that doesn't even make any sense.
No, it
If
doesn't.
somebody says,
This is like what subsets do. They say stuff and then they ask an attorney, like they haven't even approached completing a recognizable thought. Like, what do you want me to say? Just no. You might as well just come up and start speaking in Greek or something. It doesn't matter.
I paid $1,000 or rent was $1,000 a month. I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up slightly, this has been in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware. I'm aware of a whole lot in this case.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual claims after that.
Seriously.
It's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment of rent case. And it's not a cognizable claim under the statutory law.
Oh, I like this. We're not in the realm of a tenant simply not paying rent. Yeah, you want to get out of that realm because you got a problem there. So she just says it's something else. Just because I say it's effectively the Jedi mind trick. These are not the droids you're looking for.
Those damages. Secondly,
And you keep saying that. Give me some case law that says that.
Okay.
Oh, this is fun. But by the way, without looking or checking, Judge Simpson knows damn well there's no case law to support whatever the hell she's trying to say.
I'm going to move on to a second point briefly and then return to that, Your Honor.
Go ahead.
Okay.
Yeah, let's circle back. I don't have that site handy. Oh, this is too fun.
Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance line.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property. And what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000.
I'm not kidding. Her argument, as far as I can tell, is, of course my client didn't pay rent, but she's entitled to treble damages for attorney's fees. No basis. Oh, okay.
It's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
jurisdictionally or under 7? Why under 7?
right, this is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't cognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I'm giving you a brief moment.
Also, Judge, I don't appreciate your testosterone-filled mansplaining about reality to me. It's really putting me off.
My information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under MCR 4.002, not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this would be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
Okay.
I think it was, and you coming late to the game, I think I explained to the Sidonis I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was 25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it.
Okay, that'd be a no.
Come on.
Anything else?
What other crazy do you
I
have
mean,
for us?
I have to object to proceeding on a full hearing at this time.
On
For
what grounds?
the numerous reasons I've stated.
You've stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today. This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney and a party will also have to be able to. But I'd like to go off the record for a moment if it's acceptable to you.
You have any objection to that, folks? No. All right. I don't know how we're going to have this conversation, but let's do it this way. We can go off the record. Mr. Trapp, take both parties and behave yourself when you're in my hallway. Take them back to the jury deliberation room when you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there.
Keep
We're
your hands
clear?
to yourselves.
Ma'am, am I clear, Ms. Finney? All right, take them back to my deliberation room. And the court will stand in recess.
All rise.
Well, let them go, and then I'll come up. Thank you.
Second session with the Honorable J. Cedric Simpson.
You may be seated. My understanding is the parties have had further discussions. Did anything come out of that, or are we still?
Yeah, Jocelyn,
Sure.
when we came back in, she asked us to step out in the hallway. And when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take $5,200 in escrow and walk away today, that she's gonna file a lawsuit against us in a different court, that you won't be our judge, and it'll be over $25,000. So no money matters. She didn't want to talk about the money matters again. So she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
Completely misconstruing what I said. We shouldn't even be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk about
Yeah,
it. It's not going to make a difference to me.
right.
I mean, I'm just going to say this. I mean, we go back there and talk. Your client. I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one. I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before.
Right.
All right, are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes.
Oh, yeah.
I can't reasonably represent her if I'm going to misconstrue the facts.
Oh,
Well,
my God.
It's not an issue of you misconstruing the facts. I'm just telling you that there have been certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that. So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated.
All rise. 14A District Court back in session with the Honorable J. Cedric Simpson.
You may be seated. Court does call we call this the case of Finney versus Sedona. Parties are present. The record should reflect I've had an opportunity to talk with the parties, and parties have come to a resolution. I'll state it on the record and then ask for the concurrence that is the agreement. Parties have agreed to a full and final settlement of all claims that this case or have been raised in the amount of $10,000. That will be in favor of the Sedonians. That $10,000, the amount of $5,263.17
I am
will
the
be
best.
released
I did it all.
to the
I had no help.
defendants
None whatsoever.
from court escrow. The remaining amount of $4,736.83
Aside from Zach
will
doing
be
it all.
paid by Ms. Finney to the Sedonians in monthly payments over a 2-year period. And counsel, that amount, what was the amount per month that you came up with?
That was $197.33.
All right, per month for 2 years. When did she wish to begin those payments?
Next month.
April? Okay. Is there a particular date in April?
I think the 30th.
The April 30th? Would that be acceptable to? All right, beginning April 30th, 2025, until that is paid in full. Should the defendant miss a payment, default on the payments, an additional amount of $5,000 will be added to the $10,000 figure. The Sedones would then be entitled to a judgment in that amount, less any payments, which is inclusive of the escrow that have been made. All right. Also, I am the oral motion of counsel to withdraw once the order has been prepared. I will grant that, so that after that, the order is signed, she will have no further obligation to this case unless she undertakes it in some other way. That's the court's full understanding of the agreement of the parties. I'll start with you, Ms. Finney. Is that your understanding? Do you have any questions whatsoever regarding that? And I will ask this because of what occurred. You are satisfied with the efforts of your attorney in representing you today in this matter?
Yes.
All right, great. To the Sedones. Mrs. Sedone, is that your understanding of the agreement?
Yes.
Do you have any questions regarding that agreement? And you are satisfied with that agreement? Mr. Sedone, is that your understanding of the agreement?
Yes.
Do you have any questions regarding the agreement? And are you satisfied with the agreement? All right, very good. I will await the order, then I will sign it. I will thank all of you for working this out today. It has been a long haul, but I think it certainly has resolved in the best interest for all of you. And I wish all of you the best in the future. All righty. Thank you.
Thank you so much.
And I got my 1 o'clock docket. I'm going to stand in recess and then come back out. I'm going to stand in recess. They can see.
Well, there you have it. There you have it. They actually resolved it when the judge pointed out that you have no idea this case has been kicking around and your client's lying to you. The only thing that surprises me is that attorney could even understand what he was saying and figure out that she needed to resolve it.
So that's stuff. Yeah, break the law. That's all right.
I don't know what Alyssa's gotten us into here. I don't know. But Granny's not happy.
So we have you on the iPad in the courtroom, and we're just waiting for the public defender to appear.
Oh, really? Who is? I didn't hire anyone.
All right, thank you.
That's bullshit. Who hired? Pulling assigned by the court. I don't want that. No, I have to. I hired legal attorneys, not jobs. What name do you have, Your Honor? It is either a judge. She's a joke.
Yeah, it looks like Granny wants to conduct this hearing by herself.
My legal aliens. Don't know the law.
A judge does eventually show up.
Said body defender. The fuck. We already chose 3 attorneys. Paid. Attorneys.
All right, Jail, we're almost ready to go. We're just waiting for the public defender to join us, and then I'll probably do the hospital arraignment first, and then we'll do Mr. Johnson next.
Thank you.
Who is the defendant in the first place? Who is the accused? Accused by whom? For what? What's the crime? I know my rights. I know the law. And who's the judge? Beside the judge.
I did get I know my rights and who's the judge. Granny's got questions.
To begin,
She wants answers.
and who is the defendant? What is the name? Against the what? What is the crime? It's called your sheeple. The same thing last night, nothing happened. Nothing at all. No judge, nothing.
Yeah, we're all waiting.
No, nothing. No attorney, no judge. I didn't know that accused they got their own name.
Oh, I'm
So
sorry.
gets thrown out of court immediately
I'm
by
sure
a
we'll,
real judge.
I'm sure we'll get it
It's
figured out.
to
All right, Mr. Lee, we'll start with Miss Ballerini.
wrong person. Confused.
All
Wrong
right.
thing. Mistake.
All right, so we're on the record in docket 2500893. That is people of the state of Michigan versus Giannina Ballerini. Will the parties please introduce themselves for the record?
Wrong
Mr. Lee.
person. It's taken identity. Wrong nationality. Wrong everything. So,
Right, Mr. Lee, your appearance for the record.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Miss Ballerini. It should be noted for the record, I've had no previous discussion with her, but I am here to assist in whatever
All right.
capacity I can.
All right. So you have not been able to meet with Miss Ballerini?
No, Your Honor. When we did the arraignments this morning, they said that any meeting I would have with her would have to be this afternoon.
All right. So I can go, I can place you in a breakout room with Miss Ballerini to discuss. I've got two files here. One is a R&O and one is an assault and battery. Did you want some time to speak with Miss Ballerini and I could place you in a breakout room?
That would be appreciated. Thank you, Your Honor.
All right. All right. So let's do that.
I do believe we're getting counterparts.
this is an automatic.
Let's cover.
They don't hear things.
All right. So I'm going to have Mr. Lee, I'm going to have you placed in room 2, and then I'm going to place the iPad in room 2, and then we can come back and place it on the record.
Excellent. Thank you, Your Honor.
I'm not even there.
All right, Mr. Lee, did you have the opportunity to speak with Miss Ballerini?
I did, Your Honor. She has declined our representation. She claims that her name is not Ballerini, that we've got that wrong. Further, she may be more comfortable speaking Arabic. She was speaking Arabic to the police officers there. But I think she understands English too, because she knew enough to tell me that, she turned her back on me. She doesn't want us to help her is what she's saying to me. I've advised her that she's being arraigned on 2 charges today. I advised her that you will be setting a bond for her today.
Well, we'll attempt to arraign her then, and if we can't, we'll put it till tomorrow, because
Okay.
I can't arraign her. My understanding is a mental health team is on their way there.
Yes, I've been advised that as well. And I think
Okay.
that there's definitely probably some issues.
All right, let's bring her back here, and you've had the opportunity to speak with her, and so we'll see if we can run through the arraignment process. If we can't, we have our answer.
Okay.
All right, ma'am. So we're on the record in docket
Look, this was set up.
25-00893, and that is people of the state of Michigan versus Giannina Ballerini.
Fire.
Mr. Lee, we made a record previously, but you were not able to meet with Miss Ballerini. Is that correct?
Yes, Your Honor. I was able to, I tried to speak with her. she's declining our representation, and I've advised her that she's going to be arraigned this morning.
All right, thank you. And ma'am, you are Giannina Ballerini, is that correct? Ma'am, you are Giannina Ballerini? You're gonna have to say something, ma'am. You either are or you're not.
Nay,
And you are not? You're saying you are not Giannina Ballerini.
nay,
All right. And your date of birth is not 1/14/1955.
no, nay.
All right. All right. We are time set for an arraignment. These are the allegations that have been brought against you by the people of the state of Michigan. It is alleged that on or about March 24th, 2025 at 6041 South Pennsylvania Avenue in the city of Lansing, Michigan, 48911, yourself, Giannina Ballerini, did in count one assault, batter, wound, resist, obstruct, oppose, or endanger Carter Hurled, a police officer of the Lansing Police Department. With the Lansing Police Department, the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D1. It's a felony, 2 years and/or $2,000. A consecutive sentence may be imposed under the law of the state of Michigan if the assault was committed in a place of confinement, or under 750.81D6 for another violation arising from the same transaction. Ms. Ballerini, do you understand the nature of the count one of the resisting and obstructing?
From.
Okay, so
Yes,
you don't, do you understand the nature of it? You don't have to agree with it. Do you understand the nature of it?
From.
Is that a yes, ma'am?
R-A-U-D, all of you. All
right.
Please.
In count two, similarly what's been referred to as resisting and obstructing, on or about March
That's
24th,
enough.
2025 at 6041 South Pennsylvania in the city of Lansing. All right. All right. So, officer, what we'll do is we're not going to be able to arraign Miss Ballerini today because obviously. So let's arraign her. We'll set her for arraignment tomorrow. Okay.
Okay, I'll let the jail sergeant know.
Judge my ass.
All right. Yeah. She's simply not going to be able to be arraigned today, and we'll set it for tomorrow. My understanding is there is a mental health team coming from Christy Granger from Community Mental Health. All right.
Okay, sounds good.
Thank you.
All right.
Thank
Thank you.
Thank you so much. All right, go this way. That went well.
Thank you, sir.
Yeah, thank you.
Are we allowed to go now?
Well, thank you, Alyssa, for that soul-crushing depression of a hearing. Granny was not having it. She was telling him to get bent in 3 languages. She smacks she assaults a police officer, smacks the camera down, puts an end to that crap right here and now. She doesn't need any help. She doesn't need any help. She's got this handled. Lansing, Michigan. You gotta love it. Thank you all for coming out. I appreciate it.